very welcome to today's Client Experience Programme webinar on litigation trends. We'll be taking a look back at some of the big trends we've seen in 2023, and we'll also be looking at the outlook for 2024. Today's session is part of our Client Experience Programme, and the focus of that programme, as you know, is on providing practical insights on some of the biggest issues and topical challenges that are facing you and your in-house legal team. Irrespective of where you are in the world, mitigating litigation risk remains one of the top priorities of global in-house legal teams, and that's exactly where we're setting the focus of today's session. As always, we're really keen that you get the most value out of today's session. So with that in mind, we'd very much encourage you to pop any thoughts or comments or questions into the chat as we work through the content of today's session. I'm very excited to introduce you today to three of my colleagues and litigation partners at Dentons. I'm going to start with some intros, and I'll hand you over to Sandy, who will intro herself and the team and lead you through today's session.
Thank you very much, Neve, and welcome everyone to our program. We are going to go over today litigation trends. I'm Sandy Hauser. You'll hear from me a little bit later. I'm the head of litigation in the US, and I'm joined by Sarah Biglieri, who is a partner in Dentons Italy and leads our litigation practice in Europe, and by Catherine Gilfudder, who is a partner at Dentons in the UK. If you could move to the next slide, you will see our agenda for today. We're going to be talking about key litigation trends across all of our regions in a couple of key areas with significant overlap between what's going on in our various regions. We're going to touch upon trends that we expect in 2024, and then we will have time for your participation and questions and observations on what's happening in your world. So that I don't take more time away from the program, I'm going to turn it over to Sarah, who's going to introduce herself and kick us off with Europe.
Thank you, Sandra. Welcome, everybody. As mentioned, my name is Sarah Biglieri. I'm based in Milan. I head Euro practice, litigation practice, which comprises more than 270 lawyers dedicated to litigation matters. And within the litigation practice, we also have compliance, investigation, and white-collar crime. I will focus today on two hot areas, really, at European level. The first one is class action, and the second one is the ESG litigation. I'm personally involved in one of the first class actions, consumers class action in Italy, as well as in the first ESG climate change litigation in Italy, as I will explain better later. Class action will be the litigation for the next year. As you know, the European Union directive provided a uniform discipline over Europe. In many countries, prior to the directive, there was already some sort of discipline, but in some countries, there was nothing. For example, in Ireland. Now, the directive is aimed at giving an homogeneous protection to consumer rights. The deadline for the implementation of the directive was the 25th of June, but just we can see in the next slide, just 50% of the European jurisdiction have already implemented the directive within the provided deadline. In Italy, for example, is already in force. In Germany, entering into force very recently in October. The first country was the Netherlands, where the directive was implemented back in 2022, but with a small impact on the number of class actions, because prior to the directive, there was already a very strong protection of consumers and many class actions already, for example, against TikTok or Oracle, other really multinational companies. There are some countries which are in violation of European obligations, and they didn't have approved the first draft, for example, in Austria and other countries. Next, please. The directive gave to each jurisdiction some discretion in implementing the directive. So the regulation is not exactly the same in each country. I will highlight that, for example, in Germany, representative actions can started also by small enterprises with less than 10 employees and an annual turnover of less than 2 million. And also in terms of qualified bodies, they can be recognized body representing at least 75 persons or consisting of 3 similar associations, whilst in other countries the protection is limited to consumers itself. Next. In terms of opt-in, opt-out regime, unlike the US, in most European jurisdictions, there is an opt-in system. The only country, main country, where the opt-out has been selected is the Netherlands, where the opt-in system applies for foreign citizens, whilst for Dutch citizens, the opt system applies. It is important to highlight that in many jurisdictions, the deadline for consumers to opt in is at the very end of the proceedings. For example, in Italy, until the date identified by the court in the upholding judgment. In France, within a time limit identified by the court, but maximum 5 years after publication of the judgment. This means that corporations are not in a position to foresee the financial exposure. They don't know the number of consumers which may be actually involved in the representative action, and it will be difficult for the corporation to set aside a sum, an amount in their balance sheet. This is, I think, for in-house legal counsel, an important risk to be highlighted within the organization, because a representative action can be started by a qualified body, but then after a long time, after some time, also an indefinite number of consumers may opt in, and so it is not possible to understand the actual financial exposure. Next. We are at the very beginning of the application of representative actions. As mentioned, the deadline for the implementation of the directive was the end of June. We have already identified new representative actions. In Italy, we have already 5 new cases, the same in the Netherlands. I'm not aware of new cases in other, for example, in Germany, but the main areas of application are for sure consumer rights, unfair commercial practices, product liability, and also very important, we'll see also in the US, in the UK, data breach. The sectors involved are really many, and include transport, energy, travel and tourism, telecommunication, e-commerce, and banks. So no sectors are excluded from the risk of facing class actions from qualified bodies for the protection of consumers. This is really, I think, the real news because the European Union directive has introduced the so-called cross-border representative action. And I think this will increase the risk for corporations. In a nutshell, a qualified body, so a qualified body, for example, in Italy, could start a class action also in a different jurisdiction for the protection of consumers resident in different countries. So in such a case, qualified bodies could select the jurisdiction where the litigation is faster, where courts are more efficient, where there is an approach, a more efficient approach for the protection of consumer. And we expect that there will be a risk of course, of forum shopping, and that qualified bodies will organize themselves to be able to attack corporations in those jurisdictions where they could obtain, effective and very, very quick and favorable decisions. Rules of private international law jurisdiction remains unchanged, as well as rules on applicable law. But please, if you are legal counsel, now legal counsel in a multinational organization, make sure that everybody is aware of the risk that the company faces class action in any European jurisdiction for the protection of all customers involved at European level. Just to mention that there are two types of representative action. One is aimed at obtaining injunctive measures. So, for example, the first case, I'm defending the consumer association requested the judge to order to the company, to the defendant, not to include in the future some allegedly unfair contractual provisions. So an immediate order to refrain from an unlawful behavior or to the application of allegedly unfair contractual provisions. The other type of representative action by means of which consumers association may seek compensation measures such as reimbursement of money, replacement, price reduction, compensation of damages. And as mentioned before, as we don't know the number of customers, of consumers involved, the financial exposure may be really exorbitant, even if the single amount at stake is extremely small. The case I'm dealing with is like 40 euro per each consumer, but the exposure is spread over the last 10 years for really millions of consumers. So you may appreciate that even if the amount at stake for each consumer is low, the financial exposure is really high. I would like to also to mention the reputational risk, because there is the publicity is set by the directive, and in many jurisdictions there are, strict rules to make sure that the existence of representative action is, published, advertised through a number of means. So beside the financial exposure, corporation will certainly face the risk of really bad publicity. Last argument, please, next. Third-party funding is a big issue, I know, in the UK. In the US, European level, it is not yet that big. The European directive set for a very high-level discipline, just to make sure that qualified body shall be independent, and there are no competitors behind the scene to finance the class action. But to be honest, as consumers association, we not need to spend a lot of money because the discipline is really in favor of, in terms of also of legal fees and costs of consumer association. I don't see at this time a big need of funding as consumers association will be able to recover legal fees and costs after the favorable outcome of the class action. I will then pass the floor to Catherine.
Hi everyone, I'm Catherine Gilfetter. I'm a partner in the litigation and arbitration practice based in London. We in London, just to say, we do obviously the full gamut of commercial and regulatory disputes, both in litigation and arbitration, and working always in conjunction with our colleagues globally. And picking up from what Sarah was saying about the position in Europe, just take a brief look at some of the recent developments with group actions in the UK. Now, it's also a very hot topic in this jurisdiction. There's no formal class action system in the UK, so claimants have had to bring themselves traditionally within one of the 4 specific routes that are on the slide. And I think because all of these involve some judicial discretion and have generally had quite high thresholds for their grants, the UK hasn't traditionally been a destination for class actions, but there's signs this is really changing. Just to briefly explain what each of these are, representative actions, similarly to what Sarah was discussing, are where different claimants have the same interest in a claim. It can be pursued by one claimant as a representative of the group. In the UK, this is governed by the civil procedure rules, and that's generally on an opt-out basis. And the judgment, if a representative action is allowed, is usually binding then on all of the claimants. Group litigation orders are where multiple separate claims give rise to certain common or related issues, and then those common issues will be tried by a sample or lead case. And that's on an opt-in basis. And the judgment on the lead case will bind the group on those particular issues, but then of course there will be subsequent case-specific matters to resolve. Multiple joint claims, really not what we're talking about in the context of these huge actions, but that's really where you have multiple claimants on a single claim form. And that will only be permitted where the claims are really very, very similar and it's convenient to dispose of them in the same proceedings. And finally, I won't go into this in a lot of detail because we could spend an entire hour on it, but the UK Competition Appeal Tribunal is seeing a lot of activity in this space with consumer-focused damages claims for alleged breaches of competition law. Now, the system there is a little bit different. It's called the CAT. The CAT needs to grant a collective proceedings order before a claim can proceed. And that's actually quite a new regime, but it's been very well used. So the first certification was in 2021 in a case called Merrick's against MasterCard. But there's now only over 30 collective proceedings on foot before the CAT just in that time. So this is something that is clearly going to continue to cause a lot of problems for defendants. Next slide, please. Just to pick up on a couple of examples of cases that we're seeing. Now these two cases are to do with the representative actions. And I say historically, the courts have taken quite a restrictive approach to whether or not the same interest test requirement has been met. It was generally thought that really a representative action couldn't be brought if the remedy claimed included damages, because that would need to be pled and proved separately for each claimant. Now that started to change with the case of Lloyd and Google. That's a case that was involving the tracking online of users of Google without their consent. There was about 4.4 million users that were seeking to be involved in that representative. Oh, no, sorry, it was an opt-in, but it would have affected about 4.4 million users. Now, this went all the way to the UK Supreme Court, and they held that actually damages or other monetary relief was not a bar to a representative action, and really this regime needed to move on. There needed to be more flexibility and to accommodate class actions going forward. Albeit in this particular case, they didn't allow the representative action to proceed because it wasn't the case that there was a way of determining the damages to each individual. The harms were too different. However, very recent decision from 2023, the Commission against Marks and Clark LLP. This is actually a claim against a law firm which allegedly accepted secret, so unknown to the clients, commissions from a third-party provider to arrange for the renewal of the client's IP intellectual property. And actually that is being allowed to proceed as a representative claim, because the judge said that the representative rule needed to be a flexible tool of convenience, and actually it would be possible to at least come up with a common basis on which these secret commissions could be calculated, and that could then be applied successfully to across all of the claims. So again, the judge thought that case was quite different from Lloyd and Google. So moving then to Mariana and BHP. Now this is a group litigation order case, and it's a very important case for a number of reasons. First, because it's actually the latest in a series of cases that is really seeking to extend the scope of English courts' jurisdiction over claims for damages based on foreign subsidiaries' actions against UK headquartered companies. We've seen numerous claims on this theme in the environmental space in particular, and a series of quite expansive Supreme Court and Court of Appeal decisions allowing these to proceed past the stage of jurisdictional objections, even where there's really no connection to the UK beyond the fact that the parent company is headquartered there. And this one is actually the largest ever group action before the English courts, and it's now been given the firm go-ahead. It arises out of the very unfortunate collapse in 2015 of a dam in Brazil. Now there are 700,000 claimants seeking about £36 billion in damages. Now, BHP sought to challenge the group litigation order on the basis, among other things, that they said it was an abusive process, that it would be unmanageable or irredeemably unmanageable. And that was ruled that BHP was actually successful at first instance, and the group action was struck out as an abusive process, based, among other things, on really the sheer size of the claimant group. But in 2022, the Court of Appeal reinstated the group action, deciding that it just hadn't been shown why this was irredeemably unmanageable. There would be ways to manage this even if it hadn't been done before. And in any event, even if it were unmanageable, that wouldn't make the claim an abusive process, of course. And in June this year, the Supreme Court has refused permission to appeal, and so this will be a very hot case to watch for next year, because it looks like it will go to trial next October, and then we will start to see substantive decisions on this question of what the parent company's duty of care to those affected by actions of subsidiaries abroad may be. Next slide, please. Thanks. And sort of as a facet of group actions in the UK, a very important aspect has really been the rise of litigation funding. Litigation funding is allowed in the UK, and as we said on the slide, claimant lawyers and funders you really see them working together to generate claims and to identify issues that might give rise to this kind of group action. Claimant lawyers, sometimes called ambulance chasers, will promise the world, say that settlement will be very quick, very lucrative, and the market here really is has really developed very quickly to something that's very sophisticated and quite densely populated, let's say. Next slide, please. There was a very interesting decision this year by the Supreme Court, which will have had something of an impact on a number of the litigation funding arrangements that are in place for some of the most topical group actions, and that's the case of PACCAR. And what that held was, as a matter of statutory interpretation, that the provision of litigation funding did constitute, and I quote, a claims management service. And that meant that it was capable of falling in within the definition of damages-based agreements. And that is significant because that means in the UK there are regulations, the DBA 2013 regulations, which you have to comply with if you're entering into a damages-based agreement. Now, they're not especially onerous, but you'd have to make sure at the time of entering into the agreement that you complied. And importantly, actually, DBAs are completely prohibited before the CAT, the Competition Appeals Tribunal, and so that will be something of a limiting factor, or to be worked out before the CAT. So there's clearly ways around the decision. For example, conditional fee agreements based on a multiple of fees or work in progress are not captured. So it will be possible to restructure agreements that are based on a percentage of damages to still be permissible, or alternatively to renegotiate agreements to comply with the DBA regulations. But it still nevertheless caused a fair amount of consternation in the funding market, with claimants and funders having to rush to renegotiate and sometimes missing procedural deadlines because it's not particularly straightforward in a group claim involving many claimants. And yeah, so we've seen a number of claimant side law firms who have been benefiting from litigation funding arrangements discuss in the media that they'd already been exploring alternative funding models in anticipation of this decision. So, I mean, I think given the energy in this market and the number of group claims we're seeing, the PACCAR decision is unlikely to really inhibit group litigation in the UK, but it might change something of the way that claims proceed in the short to medium term.
Well, thank you, Catherine. I am going to jump in and talk a little bit about some trends in U.S. class actions. Again, I'm Sandy Hauser, and I'm based in New York, and I lead our commercial litigation practice in the U.S., which also covers arbitration, white-collar government investigations, and we are about 350 lawyers all across the U.S. Handling matters on numerous subject areas. So I think, as everybody on this call likely knows, the class action market in the US is quite mature. Unlike in Europe, and to some extent in the UK, in the United States, essentially anyone, whether they're a qualified entity or not, can initiate a class action, and can initiate a class action over really just about anything. But we also have quite a vigorous practice in the US defending class actions, which is where I end up spending most of my time. So because we are a mature market in the US in class actions, and people probably have the general background of what that looks like in the US, I wanted to focus on just a couple of trends that we're seeing in terms of the types of class actions that are being brought and what's new. And so starting here with consumer privacy related litigation, and then I'll go into data breach litigation in a minute. But there's been a huge wave of litigation over the last couple of years, in particular in the US, targeting companies' use of data, of individual records of customers, of people who are on their websites, of data sharing, either across web formats or other formats. The claims can take many different forms, although the plaintiffs' bar in the US is focused in particular on statutory-based claims. I've highlighted on this slide a statute called the Federal Video Privacy Protection Act, or the VPPA, as well as the Federal Wiretap Act. These two laws are federal statutes. There are also a bevy of state statutes, particularly in states like California and Illinois, that have particularly onerous statutory schemes governing use of data and individual privacy. The plaintiff's bar is focused on these statutes and finding any potential statutory violation, because these statutory schemes carry with them pretty onerous penalties and fines. Under the Federal Wiretap Act, it's a $10,000 per violation potential exposure. State statutes can be up to $50,000 per violation, and the Video Privacy Protection Act, which I'll describe a little bit in a minute, is $2,500 per violation. I highlight that statute because there really has been an explosion of litigation under this otherwise previously kind of unknown statute, which is targeted at what were originally thought of as videotape service providers. But the definition of who is providing video is really quite broad, because it's any person who's engaged in a business of rental, sale, or delivery of pre-recorded video or similar visual materials to any consumer who could be a renter, a purchaser, or a subscriber of goods and services. So what has happened with this law, and if you can go to the next slide, is that the focus of this litigation has shifted away from traditional video providers to basically any kind of business who's using a website with video. So think about a retailer, for example, that is showing you a dress, and you can click on the dress and see a model turning herself around so that you can see what you're looking potentially to purchase from all different angles. That now is regarded as video content. Now, that wouldn't necessarily create liability, but that is the kind of use of video. And what's happened is, or what's targeted in these litigations is providers of video whose websites also are using either Meta's Pixel or other tools like Google Analytics or TikTok Pixel or DoubleClick, by somebody looking at that video. If one of these pixels is also on the site, information arguably gets shared over to Facebook or Meta. And the argument in these cases is that this is a violation of privacy because individuals' viewing information is being shared. This is just one example of the way in which companies' use of data is a target for plaintiffs in U.S. litigation. There's also been a real uptick in data breach class actions, which I think everybody is fairly familiar with data breach class actions, but there have been numerous class actions filed within the US, basically immediately after a company experiences a breach and issues the required notifications to affected consumers. And the scope of who has been targeted in data breach litigation has also expanded in the US. There isn't necessarily expanded liability. Plaintiffs have to be able to show that there were inadequate protections because, of course, data breaches are gonna happen no matter how robust a security system you have and how many tools you put in place. Data breaches are going to happen. So you have plaintiffs arguing that the breach was foreseeable, that the defendant was aware of the risk, and that it could have been prevented if additional proper security measures had been in place. And suits are typically brought with reference to whether or not certain third-party standards have been met with respect to security, with a pretty wide variety of claims being brought for data breach. And pretty broad orders being sought, either seeking statutory damages, punitive damages, attorney's fees and costs, or injunctive type requirements that a company reinvigorate security practices, submit to periodic audits, meet certain third-party standards in terms of their cyber security program. I have on the next slide a couple of examples of the kinds of data breach litigation that have been filed and types of companies who have been targeted. So, one question arises is sitting where you all sit, which is in the Office of General Counsel or in a litigation group, or although I focused on class actions for this segment, it's equally possible that you'll see a government regulatory investigation either by the prudential regulator for the industry that you're in, or a state attorney general, or even a federal government type investigation. Really the best way to defend here, although there are plenty of defenses against data breaches as a class action under the class action law. The typical and best way to deal with the risk is obviously to make sure you have a robust incident response team and make sure, because your culpability could depend upon it, that you have evaluated your cybersecurity pretty regularly, that you've audited to make sure you're in line with the industry standard, and that you can build that kind of merits defense if need be. But interestingly enough, in the context of the data breach litigations going on within the US, there have been so many breaches, and there's so much personal information that's now out there on the dark web, that we've begun to be able to defend these kinds of actions because it is nearly impossible to trace how someone's personal information got onto the dark web. If you have an individual who's brought suit, for example, against a particular company, saying that their personal information got out, how do you know it's because of that particular data breach over which they're suing and not another one or a different one, right? Because just the proliferation of hacks and data breaches has made that the case. So sort of tying any particular individual's claim of injury to what a company actually did, coupled with the robust defense that we know all of you are on top of and are going to be able to create for your companies, makes these situations more defensible than they have been in the past. We are going to move now to another area that has been a hotbed of class action litigation in the US, but of course is on everybody's mind as a trend, which is ESG related litigation. So ESG related litigation can take many, many different forms, from false advertising class action to securities litigation to climate change related litigation. So we're going to do a little tour of our parts of the world here, and I'm going to pass it back to Sarah to start with Europe.
Thank you, Sandy. I'd like really to draw your attention to this really hot and huge topic, ESG litigation. Maybe you could think that ESG should concern big polluters only. This is not the case. The risk is there for everybody in many respects. As mentioned by Sandra, we are facing a wave of climate change, greenwashing litigations all over Europe. To start with the sector mainly concerned, oil and gas, everybody knows about the Shell case, where Shell was sentenced by a court to change the strategic plan in order to make sure that gas emissions are reduced by 45% within 2030. In Italy, the major energy company, Eni, is facing similar litigation in front of the Court of Rome. I'm defending Eni. And again, they asked to change their strategic plan in order to meet the requirements of the Paris Agreement dated 2015. But also in France, Total is facing litigation for climate change and for greenwashing, because one company may be attacked for climate change because it's for greenwashing, because it presents itself as sustainably, environmental sustainable, green. Be very careful in presenting your corporation as green, because I mean there are so many cases where as mentioned by Sandra, the advertising has been considered as false, as misleading, and corporations have been sentenced to immediately stop the advertising and also to compensate damages. But also the automotive sectors is really involved. Let's mention in Germany, Volkswagen, Mercedes, the BMW, and banks and financial institutions. I mean, being a legal counsel of a bank may make you feel safe. This is not the case, because there are many banks already in many jurisdictions, in Belgium, in France, in the Netherlands, where banks are facing litigation for failure to carry on due diligence with respect to financing corporations which are involved in deforestation activities, for buying bonds which are aimed at financing fossil fuel corporations. So every time a bank, a financial institution, or other corporation are involved in financing activity, they should make sure that they carry out with the duty a due diligence, and to check if the environmental requirements are met. So let's flag this risk, which may involve also directors' liability. After the judgment against Shell, also Shell's directors have been sued in the UK, and then now I will pass on the floor to my partner, Catherine. So the risk is very, large. May involve directors, may involve the business, so even the business strategy of the company itself, and the advertising and the positioning of the company in the market. So ESG is really a broad concept, but involves many litigation risks. Not sure that business people are already aware of that. And so I think legal counsel should make sure that organizations are ready to defend themselves, carry on a due diligence on their advertising campaign, on their strategic plans, on their financial statements. Thank you.
Thanks, Sarah. And I couldn't agree more. It's really all of these ESG litigation risks are exactly what we're seeing in the UK and elsewhere. So it's really such a global problem that a global strategy is needed. As Sarah said, I'm just going to pick up on one very interesting decision that we've had this year in the UK, and it's a novel case in that it was the first case against a board of directors seeking permission to bring what we call a derivative action, which is on behalf of the company itself. And here the NGO Client Earth argued that through approving what they said was Shell's inadequate net zero plan, and again really off the back of the Hague court decision that Sarah mentioned, the directors had breached their duties under the UK Companies Act. So the NGO said that they had failed to promote the company's success and to exercise reasonable care, skill and diligence. And of course, these are very standard duties that we really see in very many company law statutes. So I think the potential for copycat litigation elsewhere is very high. Now, the High Court dismissed the claim, first on the papers and then subsequently following an oral hearing. And the judge agreed with Shell, I think unsurprisingly, that there's a very well-established principle that ultimately it's for the directors of a company to decide how best to promote the success of that business. And Client Earth hadn't provided enough evidence to establish that Shell's plan was so flawed as to mean that they failed to act in their members' best interests. I say it's unsurprising, and that's just because given the current state of English law and the deference that is generally shown to companies' directors, the judiciary are quite cautious about extending these. And I think that's something that we're seeing and claimants will face in climate change related litigation more generally. It's one thing to bring aspirational claims, but you have to work quite hard to bring some of these actions within the very strict causes of action that we're seeing. And actually the courts, this was surprising to many people, ordered Client Earth to pay Shell's costs of participating in the permission hearing. And that really doesn't reflect the usual rule in this type of proceedings. And I think it could well have a deterrent effect on some other claimants. But it's certainly not the end of this kind of action in the UK, or as I say, elsewhere. We fully expect to see others continuing to try, probably on different facts. And even if success isn't considered likely, will still generate reputational risk. And I think that the judge's decision really made clear that there is space on different facts for this kind of claim. So it noted, for example, that Client Earth only held 27 shares in Shell and said that its motivations were possibly relevant here. So it was a minority shareholder that really wasn't driven by promoting the success of the company for the benefit of its members as a whole. And so one can imagine that with a slightly bigger stake and more support from institutional shareholders, it could have gone the other way. Sandy.
Thank you, Catherine. I'm going to go pretty quickly through just some highlights of what we've seen in the US in terms of greenwashing class action activity. I've highlighted on the next slide some of the jurisdictions where we've seen the most litigation in this area. Primarily, it's been allegations of false advertising or false and unfair and deceptive trade practices, in California, Texas, Florida, New York. You can see some of the other jurisdictions where this has been pretty much a daily type of filing exercise on class actions. The topics and things that the plaintiffs bar are focused on, if you could go to the next slide, are the first set of claims focuses on product packaging, labeling, and advertising. If you have products that you are claiming are natural, organic, naturally derived, made with natural ingredients, preservative-free, you can see on the slide all the different examples of the kinds of claims or labeling claims that have been targeted by litigants. And then the other kind of category of claims focuses on reputational claims of companies claiming their business or their products to be eco-friendly or sustainable or ethically sourced. I have in the slides a couple examples of this litigation. I'm going to go through this really quickly because we want to make sure we have time for your thoughts and comments. I think, you know, a bottom line here that I would pass on to you is that this litigation is defensible. It's particularly defensible when the kind of claims you're making are reasonable, or that your company is making about your products are reasonable, or the kinds of claims are aspirational, not specific. This is an example of a case called Schwartz versus the Coca-Cola Company, where the allegation was that Coke was falsely touting its bottles as 100% recyclable, even though most ended up in landfills, and that the claim of recyclability was also misleading because it would lead the consumer to believe that the entirety of the product, including the cap, for example, could be recycled when that actually wasn't the case. And Coke actually ultimately prevailed in the case. It was dismissed because whether or not a plastic bottle is actually recycled is not something that's within the Coca-Cola company's control. It's impacted by many unpredictable factors. I have a couple other examples for you in the slides of other cases here, but I'm just going to jump right to the takeaways for you, which Sarah and Catherine have already begun to outline, which is just make sure you're on top of this for your companies. Take a look and look regularly at what you're saying, both in your public disclosures about the company, what you're doing as a company, in any of the ES and G aspects of ESG. Reevaluate and refresh your packaging, your labeling, your advertising. Take a look at what your company is doing to substantiate the claims that are making, because if you are doing business in the US, it will be scrutinized. You could find yourself, no matter how careful you are, no matter how many disclosures you have and how much you've caveated the claims that you're making, you could find yourself on the other side of a V. In U.S. litigation, those litigations are typically very defensible, but they're just proliferating. And so it's worth doing a deep dive into the risk. And I believe I have, as our next slide here, Denton's approach here. If you're interested in taking a look at your disclosures, at your compliance, with an eye toward whether you could face litigation, whether in the US, the UK, in Europe, or elsewhere. We have a very robust team that's focused on ESG and ESG disclosures from a 360-degree viewpoint of the kind of exposure you could face. And we're happy to help you with that. I think at this point, although we do have some more high spots and topics for you that we had prepared today, I think it'd be wise to hear from all of you. If people have questions, things that are on your mind, trends that you're seeing that maybe we didn't address. We had some thoughts on M&A litigation and securities litigation, but we would like to hear from you if there are questions you have for the three of us. Neve, we also have a poll, I believe, so that we can get a sense from you as to what's on your mind.
Let's do that. So the question is, which of the following areas do you feel presents the most litigation risk to your global organization? So in the context of what you've heard today and in thinking about your own global organization, maybe it's consumer privacy and data breaches, perhaps it's greenwashing and climate change after some of the updates you've heard just now. It may be M&A, might be securities litigation, or perhaps even more the traditional risk areas like employment litigation, or maybe there's something else that's really high on your priority list in terms of risk in this area. So it's lovely to see everyone participating. We will give it just a few more seconds for everyone to get involved. Excellent, and let's do a quick countdown. So let's go 5, 4, 3, 2, 1. Great, I'm seeing the last minute votes coming in. So we'll end the poll now and share the results with you all, which is interesting from a benchmarking perspective as well. So Sandy, I'm keen to get your views on this one.
Well, this is not at all surprising. Top on the list, it seems for everybody, or for more than half of you, is consumer privacy and data breaches. I think you are, well advised to be concerned about that, given the exposure and the proliferation of litigation. More traditional risk areas comes in second, which is interesting. We didn't talk in the panel today about employment. We do have a very robust employment practice within our firm. So look ahead and we'll try to schedule another session focused around employment risk. We've got greenwashing and climate change here, also on everyone's mind. So quite interesting results from all of you. Any closing remarks, Catherine or Sarah?
No, it's really interesting. I mean, it absolutely reflects what we've been seeing in the UK too. And I think it just shows how the global landscape is developing and the need to really keep surveying the case law in different jurisdictions, because claimants will be opportunistic and seek to exploit helpful decisions in these areas that are developing so fast.
Yeah, and I think also in Europe, the litigation arena is becoming, similar to the US and UK. So I really do expect more consumers class actions, and so a really bigger risk for our clients. So let's keep an eye on that, and we will update you, because we are just at the beginning of the journey with the implementation of the directive. Next year, we'll follow the trend, but I'm pretty sure that we will face an increased number of disputes.
And I would just like to thank everyone for attending today. If you have topics that you would like to hear about or see us present through one of these seminars, you are our clients and we are here to serve you. And if there are things you want to hear about or discuss, please just shoot us a note, let us know. And we're happy to either schedule something privately with you or to put on another one of these fabulous CX seminars. Back to you, Neve, to close us out.
Just a huge thanks to everyone who's joined us, not just today, but over the last number of months and beyond in terms of this series. I want to say also a big thank you to our panelists who put such time and thought and consideration into today's session. So we're already looking forward to having you all back again with us, hopefully. We are taking a little break over the new year. Lots of sessions, as Sandy said, coming up in 2024. So we're looking forward to seeing you back online in the new year. That's it. That concludes the session for today. Thank you for joining us.